Thanks for joining this episode of the Number 86 Lecture Series, where we discuss basic principles and applications of tort law along with landmark cases. Today's episode features Gregory Dolin, who is a professor of law at the University of Baltimore, where he teaches torts, contracts, property, intellectual property, federal courts, and constitutional law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Professor Dolin, in a previous podcast, we discussed the centrality of negligence and duty of care in modern tort law. Is the duty of care standard the same in an emergency?
The duty of care is always the same, right? The duty of care, you always have to act reasonably. But what that involves may vary with circumstances. So, for example, again, something we know from our everyday life, you probably ought to drive somewhat differently if the road is covered by a sheet of ice than you can drive on a very dry summer day. You probably ought to drive a little differently at night than you should during the day with great visibility, or in the fog when it's clear visibility. So the duty stays the same. You still got to act reasonably, but what it means might change from time to time. We talked earlier a bit about emergency. And so I said, at least in the world of intentional torts, emergency is really not its own doctrine. It's more kind of bleeds into necessity. But what about in the world of negligence? Well, it turns out emergency doesn't actually change the answer. You still have to behave reasonably. However, of course, what's reasonable in an emergency may be something different than what's reasonable in non-emergency. So just last semester, for example, on my final exam, I had a hypothetical where one of the parties involved was driving his pregnant wife to the hospital, who was in the middle of delivery, middle of giving birth, and decided to run a red light while, signaling and flashing his lights, etc., that he's going to run the red light. Now, is it reasonable to run red lights? Generally speaking, no. That's why we have laws about running red lights. Might it be reasonable to do so in an emergency, right? When it's actually maybe safer to get a woman who's in the middle of giving birth to the hospital earlier than to stand and wait for a red light? Maybe, but notice again, the standard is the same. It's still reasonable. But in one circumstance, it may be unreasonable to run a red light. In the other circumstance, it may be reasonable to run a red light. And then the final point is what matters are in determining what is and what is not reasonable are kind of surrounding circumstances, right? Is it raining? Is it foggy? Is somebody giving birth? Are you trying to escape people who are shooting at your car? Whatever it is. What generally doesn't matter are your own peculiar situations. So being stupid, as in Vaughn versus Menlo, doesn't matter. Being a novice driver doesn't matter, right? Being a young doctor doesn't matter. You have to meet the standard of reasonableness or don't. Basically, the message is, if you don't know how to do it, don't do it until you learn.
With these reasonableness standards, are there any exceptions or distinctions for certain groups or types of people?
There are exceptions in a couple of circumstances, although I'm not even quite sure it's best to think of them as exceptions, as perhaps variations on it. So, for example, children are generally not held to the same standard as adults, but only when children are engaged in childhood-like activities. So if a child, and anybody who's 16, at least legally is a child, they're not yet at the age of maturity, anybody at 16 gets behind the wheel of a car, even with a license and everything, so we're not even talking about people going for a joyride. When they start engaging in adult-like activities, they're held to the same standard as adult, even if they're legally a child. But when a child is engaged in childlike activities, they're playing ball on the street, they're, doing whatever things that children do, right? They play hide and seek, whatnot. Then they're held to the standard of a child of like age and maturity. And that is obviously at least somewhat of a variation on a reasonable person standard, because when you're engaged in adult activities, whether you're a child or an adult or a really old person, right? So an 80-year-old is held to the same standard of driving as a 40-year-old who's held to the same standard as a 16-year-old. So why do we hold children to a lower potentially standard when they're engaged in childlike activities There are several explanations. One is that children may not, if the idea of tort law is to help people adjust their behavior to societal expectations, well, then children may be too young to really understand it. So the law is not going to help them. It may also be that we want children to kind of explore the world, to figure things out for themselves, and to hold them to the same standard as adults who already have done that may not accomplish that goal. So for children who are engaged in this childhood-like activities, the standard is a little different. Still doesn't mean anything goes. They still have to act like a child of a similar age and maturity. They can't just say, well, I'm under 18, so I can do whatever I want. But they don't necessarily have to live up to this generic reasonable person standard. The other time when there may be, and again, not so much an exception, and maybe this is not even a variation on the standard. Maybe this is just kind of a way to satisfy the standard. So there's this great case that I teach called Padula versus State. It comes from New York. Mr. Padula was admitted to a psychiatric institution in New York for a drug addiction. I believe he was admitted somewhat involuntarily, but nevertheless. And so he was there with a number of other similar situated people. One day, him and his buddies at night, they broke into a medicine cabinet that was not apparently very well locked. And they made themselves drinks with Tang mix, orange mix Tang, and methanol. Now, methanol looks and tastes and feels exactly like drinking alcohol, which is ethanol. The only difference is a single carbon atom. The problem is ethanol, which those of us who drink like and enjoy, tastes good. And, that basically is the entire consequence if you drink it in moderation. Methanol, on the other hand, can kill you. It's not something the human body is able to process, or it can make you go blind. It's really inadvisable to drink methanol. And what's interesting, Padula knew that. And to the extent that he wasn't sure the bottle that him and his buddies used had a giant skull and bones on it and a warning saying, do not drink, can cause all sorts of problems. And yet they ignored it, they drank it, and with predictable consequences. And then Padula sued the state. And it comes from New York, so I always tell my students, imagine the chutzpah, right, to do that. Saying you broke into the cabinet, you drank the bottle that specifically said not drink, and then you go ahead and sue. Interesting enough, Padula wins. Right? Why does Padula win? How could it possibly be reasonable for an adult person who can read, and even if he can't read, he can see the skull and bones, to drink that? And the answer perhaps, although there's no multiple explanations, but perhaps the answer lies in the following. We ask, what would a reasonable drug addict or alcoholic do? What would we expect of a reasonable person in that circumstance? And the answer is we would expect, if the person can't really control themselves, to check themselves into a rehab facility. That's what a reasonable person trying to work or deal with that affliction do. And what did Padula do? Well, he did exactly that. He checked himself into the hospital. He put himself into the care of this institution, saying, I'm unable to control my urges. That's why I'm asking you to do it for me. And what did the hospital say to him? Said, okay, we will take care of you. And what did the hospital not do? Right? They didn't lock the methanol properly. They allowed Padula and his friends to break into that cabinet. And so while, like I said, perhaps it's not an exception to the standard of care, and maybe not even a variation, but you can see how, although on the surface, we can think, how could it possibly be that drinking, someone says, do not drink, makes you reasonable? And the answer might be, well, because you have already done everything that we would have expected of you. You've checked yourself into the hospital, not just into a program, but into a residential facility. We can't expect more out of you. So no, there's not really much exceptions, but there are these interesting variations as to figure out, like, well, when will we say you've done enough? So what happens when a person is disabled? So I've said before that generally we do not take into account person's individual circumstance, right? So the fact that you're a novice, the fact that you're not particularly knowledgeable, the fact that you're not maybe very smart, we don't care. We generally say, well, if you don't know how to do things, if you're unable to do things, don't do them. But what happens when a person is disabled? Are we really asking a blind person to see what a sighted person would see? I mean, and maybe the answer ought to be yes, saying, well, it would be unreasonable to expect people not to look where they're going. But of course, it presents real problems because the world, again, tort world recognizes that the world is imperfect. It exists as it exists, and we need to encounter it kind of on its own terms. Unfortunately, the world does have people who, through no fault of their own, are disabled. Some are blind, some may be deaf, some may have a seizure condition, all sorts of other things. So how do we treat them? And the answer is they have to behave like reasonable people in like circumstances.
Tell us more about what that means. How is the reasonable person standard applied in a case where someone has a disability or other extenuating circumstance? In these cases, how much responsibility falls on the shoulders of the plaintiff versus the defendant?
If you're a blind person, you shouldn't get behind the wheel of a car, right? It's unfortunate that you have that disability, but a reasonable blind person, much like, for example, Padula, what would a reasonable person afflicted with addiction would do? He would check himself into a hospital. What would a reasonable blind person do or not do? Well, a reasonable blind person would not get behind the wheel of the car. At the same time, are we going to require the blind person to become sighted? No, right? So one case I teach is actually a great case because it comes up in San Francisco and right around the gold rush. And it's fun to teach it because I get students to think what is actually happening on the ground, not just in the law books, but on the ground. And if you think about what was happening in San Francisco at the time, right, it's almost exclusively a male-only town, right? Women have not yet arrived. There's just a bunch of men trying to strike gold. And pre-Netflix, pre-internet, how to entertain themselves? They drink, right? And one day, there's our plaintiff, he walks home drunk on an unlighted street. There's, again, pre-really electricity widely being available. And the people who were doing street repairs left and they took him as sort of a manhole cover and they left it open. And our person falls right in. And the company says like, well, should have been looking where he's going. The Supreme Court of California said a drunk person, or by extension a blind person, is entitled to safe streets no less so than a sighted person or a sober person. So how does that get back to disability? We take into account the fact that sometimes people are drunk, sometimes people are blind, etc. Does that mean anything goes for them? No. We know what blind people have to do to be reasonable. They have to walk around, if they want to behave reasonably, with a seeing-eye dog or with one of those canes that sort of tells them where they're going, or somebody helping them, or maybe with new technology being available, with sort of orienting themselves by their hearing, or whatever else. They have to adjust their behavior. Again, remember, tort is a behavior adjustment mechanism. They have to adjust their behavior to their own disability. So they don't get behind the wheel of the car. They do get those walking canes. But in turn, we adjust our behavior to recognize that not everybody is sighted. So we don't leave open manhole covers thinking that, well, a person who has eyes will see, because not everybody has them. So again, the standard is the same. You have to behave like a reasonable person. But that standard does take into account the fact that some things about you cannot change. You cannot change whether or not you do have eyesight or not. You can make adjustments for it. So you don't engage in some activities, you get some additional help. So you still have to behave reasonably, not anything goes. But it's a two-way street. We make adjustments for you, but you have to make adjustments in your own behavior, take into account of your own disabilities as well.
Are there circumstances in which a plaintiff is held entirely responsible for his own injury? For example, if he was knowingly and voluntarily engaging in a risky activity?
Assumption of risk is a defense available to a defendant, tortfeasor. Of course, defendant carries the burden of proof. And it basically goes something like this. The reason you, the plaintiff, are injured is because you engage in a dangerous activity and you voluntarily chose to engage in that dangerous activity. So for example, you went ice skating, right? It's wintertime now. DC at some point, well, if it doesn't already have like an ice skate somewhere near our National Gallery of Art, you go ice skating. And while ice skating, you fall and you break your leg. It would be somewhat weird to complain like, well, the ice is too hard. Well, I'm sorry, but the ice is supposed to be hard. That's what makes it ice and not water, right? And one of the inherent risks of ice skating is falling, because ice is also slippery, and breaking your leg, right? So that's the assumption of risk. which is why when you go engage in particular sports or particular activities, you get to sign a whole bunch of waivers, right? So if you go skydiving, they say, look, there are chances that, wind might blow and you might get tangled up in a high power lines, right? That's a risk that you assume, right? You might go diving, scuba diving and say, look, there sometimes are currents and you might get washed into the sea and be lost forever. That's a risk that you assume. So now, of course, you don't necessarily assume all risks. So, if you go skydiving, you might assume the risk that, wind will blow. You don't necessarily assume the risk that instead of a backpack with a parachute packed in it, accidentally your instructor will give you a backpack with a bushel of apples, right? So, but you oftentimes assume the risks that either inherent in the activity, such as, that ice is hard, or, again, to go back to the ice skating example, imagine you show up to the ice rink and you see that, maybe the ice rink owner is not actually doing a very good job upkeeping it. And so the ice is slowly melting. And so you have a film of water, right? Making, of course, ice more dangerous than usual, right? Nobody owes you to make ice not ice. So if you want to go ice skating, it's going to be on a hard surface, right? Nobody owes you to make, ice soft. But if you're running an ice rink as an owner, as an operator, you do owe a duty to maintain it. Suppose you breach that duty and there's this film of water, which makes it more dangerous than otherwise. The person comes in, they see the film of water and say, you know what the hell? I'll go skate anyways. I know it, I see it, I appreciate it, but I really want to skate so much that I'll do it anyways, right? That's also assumption of risk, right? You see the danger and you choose to voluntarily encounter it. I can tell you sort of the story of my life that I also always tell my students. When we were in the process of immigration, when we were living in Italy, my grandmother fell ill and she was taken to a hospital. And, we were immigrants, we didn't really have any money. And so we couldn't really afford to go visit my grandmother daily on a bus. And so my dad asked our landlady to let him borrow a bicycle. And so she was gracious enough to give us a bicycle. But she said, it doesn't have brakes, so you may need to go to a local city dump and get, those brake pads. So the bicycle had brake pads, but they were worn down to a nub. So I, at the time, was 12. I saw it. I'm like, hey, new bicycle. I'm just like, don't ride it. It doesn't have functional brakes. But I saw it. it had nubs. I'm like, it's fine. It's going to be okay. Of course, I rode the bicycle, and it, when I rode it 2 miles an hour, it was indeed fine. And so I increased the speed. Finally, I decided to roll downhill and make a sharp turn to the right. And of course, couldn't stop it because it did not indeed have brakes, and ran straight into a wall, broke my finger, got no sympathy from my parents because why? I assumed the risk. They told me not to do it. I said, I'll do it anyways. Despite the danger, I got hurt by the very danger I chose to voluntarily encounter. That's assumption of risk.
How do courts handle cases where both parties were both clearly at fault to some degree? Is a case automatically dismissed if the plaintiff contributed to the accident in some way?
So traditionally, in a world of tort law, any negligence on the part of the plaintiff was a complete bar to recovery. Even if defendant was 99% negligent and the plaintiff was only 1% negligent, any contribution to your own injury completely barred recovery. And so that doctrine is known as contributory negligence, not comparative, contributory negligence. And you can think of two justifications for that doctrine. One is that it incentivizes people to be careful about their own health, about their own life, and kind of force them to adjust their own behavior. And number two, you can think of it almost as a echo of the fundamental doctrine of equity, that he who comes to court must come with clean hands. If you yourself are not really careful, if you don't care about your own life and health, why should the court care about you? But that potentially creates serious inequities. So even though you've only did very, very little, right? Like I said, you're only 1% responsible for what happened to you, while the other side is 99% responsible, you get no compensation at all. And that's, even though it's the other side that ultimately created a greater loss, they completely escape responsibility. And again, that creates a problem both from kind of this moral fairness perspective and also potentially economic perspective, because you can be pretty careless and still get lucky enough that, if you can manage to prove that the other person was even just a little bit responsible, completely escape responsibility, and thus basically chance that and instead of adjusting your own behavior. So in response to these inequities, courts have begun to develop a doctrine actually adopted in 45 states. The only jurisdictions in the U.S. that have not adopted or have stuck to the old contributory negligence doctrine are Maryland, D.C., Virginia, North Carolina. You can see the pattern. And also, strangely enough, Alabama, right? So it's kind of this mid-Atlantic states and Alabama being the holdout. So most states have adopted in one form or another comparative negligence doctrine. And that doctrine basically says, okay, there was an accident. There was a damage, let's say, of $10,000. Let's figure out who contributed how much to this. Defendant did X, Y, and Z, and that contributed 80% to that $10,000 loss. The plaintiff also was not super careful, and so he did A, B, and C, and he contributed 20% to his own $10,000 loss. So we should compensate him. How much did he lose? He lost $10,000. How much of that was because of his own actions? Well, 20%, that's $2,000. So how much should he get compensated for by the defendant? 8. Right? So you don't compare negligence to the perfect world. You compare negligence between the parties. You say who was more and who was less, who contributed more, who contributed less, and each party pays in proportion to their contribution to the final damage. Again, this has been adopted in different forms everywhere. Some states have adopted pure comparative negligence. So even if defendant is only 1% liable and the plaintiff himself is actually 99% at fault, defendant will still pay. He'll only still pay 1%, right? But he will still pay for his own contribution. Some states have adopted the rule saying that the only time defendant will pay is if he contributed more than the plaintiff. Some states have adopted the rule saying that the defendant has to contribute not just more, but has to contribute over 50%. Some states have adopted the rules. For example, you can have one plaintiff, 3 defendants, right? So let's say the plaintiff contributed 40% and 3 defendants, between them 20% each. So but together 60, right? So some states have adopted the rule saying the plaintiff cannot recover unless any given defendant that he is suing contributed more than the plaintiff himself. So there's a variety of ways that the states have adopted the rule. The classical one is the pure comparative negligence, where you just pay in proportion to the damage you've caused. And now plaintiff's own actions do not completely bar recovery. They just reduce the recovery based on the amount of fault that the plaintiff himself contributed to the ultimate injury. It's both the same and different contributory negligence. It's the same in the sense that analysis is exactly the same. You're still asking, was the plaintiff careful? If not, like where did he fail? If he failed, was his failure actually a cause of his injury, right? Because contributory negligence and comparative negligence is analyzed exactly the same way as regular run-of-the-mill negligence, just now we're focusing, instead of on the defendant, we're focusing on the plaintiff. So in that sense, they're exactly the same, whether you're doing contributory negligence or comparative negligence doctrine. And the only difference in the outcome, if the answer is that the plaintiff contributed in any way to their own injury in a world of contributory negligence, so if you're in D.C., Maryland, Virginia, North Carolina, or Alabama, you get no recovery. If you happen to be in Delaware or New York or California, you will get reduced recovery, reduced by the amount of negligence that the plaintiff himself brought forth.
Thank you for listening to this episode of the Number 86 lecture series on tort law. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to number86.fedsoc.org for lectures and videos on federalism, contracts, jurisprudence, and more. Thanks for listening. See you in class.